Can a judge order a defendant detained just to perform a competency exam? To find out, you have to read Molinaro versus the Warden of Rikers Island. It's only 11 pages. Don't have time for that? I got you covered. This is the TLDR episode on People versus the Warden of Rikers Island. This is New York Slip Opinion 07093, a Court of Appeals case published on December 15th, 2022. This is a case where the issue is what authority the court has to remand somebody, meaning put them in custody without bail, on the basis of ordering a 730 competency exam in a criminal context. So, in order to understand and appreciate the nature of this case, you have to understand what the situation was before the new bail reform, which took place in around 2020. 3 years ago at this point. For the longest time, arraignments are trying to accomplish three things. At an arraignment, at a criminal arraignment, where a person is advised of the charges against them, there are notices that are given by the people or defense to advise them of what rights or what things are being demanded or what rights are being invoked. And thirdly is the question of bail, which is the very important question from the perspective of both the people and the defense. That's a question of where will the defendant be while this case is pending? Will the defendant be incarcerated while the case is pending? Or will the defendant be out in the community while the case is pending? Along comes bail reform around 2020. And bail reform in New York changed the whole landscape of what happens at arraignments. It changed the nature of how many times counsel are being retained versus legal aid being assigned in the practical sense. And it also changed what kind of crimes can lead to bail or remand. Because what bail reform did is it said certain kinds of crimes are non-qualifying offenses, meaning not qualifying for bail, and certain kind of crimes are qualifying offenses where the court has the authority to order bail or remand. Certain other crimes can have remand. Now, because of the bail reform changes, the non-qualifying offenses means that a court can order pretrial supervised release or can just ROR the person, meaning release them on their own recognizance. But there's a certain provision of the law called CPL 730, Article 730, that allows, when a court has a suspicion that a person may not be competent to stand trial, they order a 730 exam where doctors examine the defendant to determine whether or not the person is competent to stand trial. Historically, and I was an ADA for 7 years in Queens County. Historically, frequently what happened at arraignments is if a 730 was ordered, the person was put in. It would be an in 730 exam, generally. And that would mean they'd be incarcerated pending the outcome of the 730 examination, which might take 30 or 60 days, at which point there'd be a 730 report telling the court whether or not the person is competent to stand trial. But because of the bail reform and the fact that certain offenses are non-qualifying, they would not be eligible to be put in jail on bail or remand. So this case addresses the question of, in a non-qualifying offense case, where the defendant, in this case, Wei Li, was accused of a non-qualifying offense, did the court have authority? Could the court legitimately remand a defendant under 730 for the purpose of ordering a competency exam? And the Court of Appeals says no. Says no, a court doesn't have that authority. The court says that the provisions of 730 say how and where a competency exam can be ordered or take place, but that there's no authority granted by 730 itself to remand a defendant. If a defendant is otherwise remanded or a defendant is otherwise put in on bail, then you can order an in 730 exam. But if a person is not even eligible for bail anyway, then you cannot order an in 730 exam and put them in solely because they're suspected of lacking competency. And that's essentially the holding of People versus the Warden of Rikers Island. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.